a number of times in the past, and the reason why it's important now is because, and there's a section of the seminar I'll be talking about this, the Office of Civil Rights under HHS is now conducting audits in this area. So it's extremely important to understand what the responsibilities of an employer they have under HIPAA privacy if you store or transmit PHI. So what I'm going to do today is review what an employer has to do if they store or transmit PHI, what PHI is, what are your responsibilities, and it's based on the compliance issues involved, what documents you have to have in place, what do you have to do procedurally in order to comply with HIPAA privacy. It's extremely important to understand, and I'll be going through this, the penalties in this area if you are found to be not in compliance can be rather severe. Now, in the past, what HHS has done, they have audited basically hospitals and doctor practices. And there's been stories in the paper about certain practices and certain hospitals being penalized because they didn't comply with HIPAA privacy. Now they're going to switch and start auditing business associates, which is anyone who has access to your protected health information, and also employer plans. Now, what's interesting, you'll see this in the next few minutes when I go through this, but basically they're going to communicate to employers through email, and you'll get a notice from the Office of Civil Rights, OCR, that you've been picked for audit. And so don't delete the email. Look at it, and I'll be discussing what do you have to do if you get one of those, if you're one of the lucky individuals to get one of these emails. Because first it's going to be a desk audit, which means they don't come out and visit you. Afterwards, if they see any issues, they may come out and audit you. So I'll be talking about this. So what I'm going to be talking about today, as I indicated before, is how you can comply for HIPAA privacy, and what do you have to do, and when do you have to comply. So health plans are required to protect and safeguard a participant's or covered dependent's personal health information, PHI, from the impermissible use and disclosure that must obtain a patient's or employees for certain uses and disclosures. So what we're talking about here, and I'll be defining what PHI is in a few minutes. So as an employer, if you're self-insured, absolutely, that you have access to employees' protected health information. But if you're insured, you have to be very careful to see, do you store or transmit PHI? And if you do, there's certain things you have to do protected information. You have to determine what information you have in your existence is information that has to be protected. And then what you have to do is take steps to protect that information. You have to demonstrate when you get audited by HHS if you've done so. So what has to be done? Well, health plans must establish written policies, procedures to protect PHI, protect and safeguard a participant's or covered dependent's personal health information, obtain a participant's or covered dependent's written permission for certain uses, and generally it's outside the basic running of the plan. Notify participants and covered participants of policies and disclosures and use of PHI. Report any impermissible use of PHI. Allow a participant or covered dependent to inspect or copy PHI. And when you're using PHI, this next one is very important, only use what's minimum necessary to accomplish your goal. So if you have one piece of information on a page, you just copy that one piece of information, not the whole page. And it's also very important, if you store and transmit PHI, you have to enter into business associate agreements with any entity that has access to your PHI, which includes your broker, it includes your TPA, it could include your computer people that have access to your computer records. So it's extremely important to understand what you have to do and when you have to do it. So I've been talking about this. What is protected health information? It's all medical records and other individually identified health information held or disclosed by health plans in any form, whether communicated electronically, on paper, or orally. Health plans may release PHI to employers without authorization in very limited circumstance. And 3 conditions must be met. Provider must provide service at the request of employer. For service provided may relate to medical surveillance in workplace. And employers must have a legal requirement under state or federal to keep records. Now, in the past, employers have been very confused because clearly a hospital or doctor practice has PHI. It's medical records. It's claim information. And in many situations with employers with their health plans, they also keep and transmit claim information and sometimes enrollment information that contains personal information, name, social security number, condition. If you store and transmit PHI, then basically what you have to do is you have to comply with HIPAA privacy. So what are the plan sponsor's obligations? But group health plans don't need to obtain the participants' or covered dependents' consent to release information for the administration of the plan. But what you must do is go through the gyrations of adopting these policies and procedures in order to do that. Because if you don't adhere to these rules and have this in writing, technically you cannot have access to any of the employees' PHI. And in that situation, if you don't comply with these rules, you cannot, without the employee's permission, help them with claims, discuss any information about your plan with your broker. So that it would be really tough for an employer to administer their plans or help employees with claims unless they have access to PHI. Now, if you only have summary health information, not individualized for each employee, you don't have to comply with these rules. But if you do have access to PHI, there's required plan amendments, and then there's obligations when you do have protected health information. So what documents do you need to comply if you do store and transmit PHI? You have to create a HIPAA privacy policy that indicates what you're going to do with that possession of that PHI. Come up with procedures, what's called a HIPAA privacy use and disclosures that demonstrates how you're going to put that policy into place. Notify your employees of what you're going to do and what their rights are. That's called a notice of privacy practices. Enter into a business associate agreement with your broker, your TPA, any outside entity that has access to your PHI. Authorization for release information. If you are unsure, if you're in compliance with HIPAA privacy and you want to use any type of protected information and you have it completely comply with HIPAA privacy, then you need to have an authorization form from the employee or dependent to have access to that PHI. So if you have access to PHI, then you have to amend your health plan to provide for that. You have to amend your health plan SPD to indicate you have access to PHI. And then you, as an employer, have to certify to the health plan that you can comply with all the HIPAA privacy rules. Other forms include, and you have to have in your possession, a request to inspect or copy PHI, a form called a request to amend and correct PHI, because individual participants and dependents have a right to look at their record. A request for accounting or disclosure PHI, an employee has a right in that situation to say, hey, tell me who you've actually sent my information to. And so they have a right to see that record where you've sent that claim information to. And employees also have a right to restrict the use and disclosure of their PHI employees may say, well, don't send any information about the health plan to me, but just give it to me at work. Don't send anything to the house. And you as an employer have to comply with those restrictions. Now, health plans are allowed to use and disclose PHI for the following circumstance. So, as required in accordance with an individual right to access PHI for covered functions, treatment, payment, or health care operations. So if you do comply with HIPAA privacy, you don't need to get the individual's permission every time you administer your health plan. You don't need to do that. With respect to specific types of information after the opportunity to agree or object, you can disclose information to third parties, and I'll be talking about that. For example, if an employee calls you up on the phone and has questions about their claim that you are helping them with, and they have a friend on the phone with them, helping them, in that situation, you can disclose that information over the phone, or if they bring a friend to a meeting, you can, in that situation, disclose protected health information to that friend. But again, if that friend calls back without the employee on the line, then you have to request an individual authorization from that participant in order to disclose any information to a third party. But in addition to that, you have a requirement under the law in certain circumstances because of a crime or public policy because of flu epidemic, to disclose information for public policy exceptions, and I'll be talking about that. So for treatment, payment, and healthcare operations, again, in running the plan, every time you pay a claim or have a question about a claim that you're working with your broker or the insurance company, if you comply with all the HIPAA privacy rules, every time you look at the information, you don't need to get the authorization from the individual participants. So that includes for their own treatment, payment, and healthcare operations, for the treatment activities and other healthcare providers, to another covered entity, the insurance company, for payment activities, and to another covered entity for certain health care operations. So in the running the plan, if you adopted all the HIPAA privacy rules, every time you do what's contained on slide 10, you don't have to receive individual authorizations from the participants to do that. So again, health plan may use and disclose PHI for individual has had opportunity to prohibit the disclosure of such information. And again, it's up to the employee to restrict how their information is used. So again, if they don't want information, for example, you could put in your HIPAA privacy that you're not going to disclose any information about a participant to any of the family members. And you can do that. So you can restrict who you give information to. So a spouse, for example, couldn't see the information of the participant and vice versa. And it's up to you, the employer, to communicate those restrictions. In any situation where you're unsure, and when a third party calls or when a family member calls and somebody from the plan is talking to them, if you're unsure whether that individual participant has given an authorization, what you may want to do and tell your people in your HR department is that anytime any information is asked to be disclosed and they're unsure whether it's authorized, you may request an authorization from, again, a participant for any purpose. And so that way you're protected and you know that that disclosure is going to be permitted. Now, health plans may disclose PHI without authorization if it's required by law because of a crime to certain designated public entities, individuals, and the employer, regarding individual victim of a designated abuse or other certain conditions, to a health oversight agency, in response to certain court proceedings, if you're subpoenaed to provide that information, especially in a court proceeding, especially a divorce situation, To law enforcement officers, if certain conditions are met, they identify themselves and they tell you what the purpose of it is. To a coroner or medical examiner for ID purposes. To an organ procurement organization for transplant purposes. To prevent a health threat, especially if you have a flu epidemic during the wintertime and a local agency is asking for the information. For certain specified governmental purposes and to comply with worker comp purposes. So this is all under the public policy exception. Also, information can be disclosed for health underwriting, for placement of insurance. But again, be very careful in that situation because some authorizations could be warranted in some situations. It's not a blanket exception. Also, and again, depending on your policy, you could disclose information to other third parties, a member of a family. It's up to you what your policy, but you have to communicate those policies, especially if now, because of the fact families can cover children up to age 26, and that, for example, dependent is age 22 in college, and so that person's above majority, and whether that information can be disclosed to a family member. In that situation, I'd be very careful. And you could have a policy that, I'm sorry, once you reach majority, that information cannot be disclosed to any other family member, even though you're covered by the plan. And in order for that information to be disclosed to a family member, you have to get an authorization. Now, clearly, a parent's authority in that situation for dependents under age 18, that situation is different. Also, it's up to you how you want to treat the spouse's authority. You want to indicate in your policy that you will disclose a participant's information to their spouse. And if, as an employee, if you want to make an exception, say no, you have to tell us. So unless you tell us otherwise, we're going to disclose information to your spouse. And if you don't want information about your claims communicated to another family member, you tell us otherwise. So you have to communicate that. So again, what is required for HIPAA policy and procedures? If you store or transmit PHI, health plans must establish policies and procedures with respect to HIPAA standards, how to implement those standards, and also how you're going to protect individual rights of the participants under the plan. Also, you have to provide employees a privacy notice indicating what your policies are. So who is required to provide these notices? Covered entities, health plans. What must the notices describe? The use and disclosures, what you can do with PHI, what the individual rights of the employees are in regard to that protected health information, and what the health plan is going to do to protect that information. So again, what are the health plan's duties? They must provide their own protected health information or health notices if they do have access to PHI. So you can't just merely communicate and distribute the insurance company's notice information if you actually have access to PHI. So you can have, another entity provide that notice, like a TPA, in certain situations. So what you have to do is, again, appoint a privacy officer. So what I'm warning you in this situation, what the government's looking for, you can't just set it and forget it. When these rules first became released in 2003 and 4, everybody went out and bought a manual with all the policies and procedures, and then they adopted it and then put the book back on the shelf and didn't look at it for 10 years. That's not going to fly with HHS. What you have to do is you have to designate a privacy officer. The privacy officer is, again, responsible for the development and implementation of the policy and procedures. And it can be one privacy officer, or if you have more locations or more subsidiaries, you can have a privacy officer at each location. Also, especially if at the locations, you could have a contact person. Because basically what you have to communicate to your employees is if you see a violation of the privacy policies, you have to communicate that to the contact person if there's violations. So that person, again, can communicate what the rules are. They have to, again, make sure that everything is distributed. So the contact person is, and again, these are the only individuals at your place of business for the health plan that can actually have that can actually have access to PHI. Now let's stop right there. I've been talking for a while. And Amanda, do we have any questions?
We don't have any in the text box, but I will unmute so that people can ask.
The conference has been unmuted.
Amanda, do we have any questions?
We don't have any in the text box, but I've unmuted so that people can ask if they have any.
Does anybody have any questions so far? Anyone?
Oh, does any of this change with regards to a self-insured plan?
Well, these apply to both insured or self-insured plans, and it's less likely that employers have access to PHI for insured plans, but clearly it applies to self-insured plans and includes insured plans if you regularly store or transmit PHI.
Mm-hmm.
So, and generally where employers get involved in that, if they actually have access to claims information in this situation, then that is actually having access to PHI.
Got it.
If I'm sending out a census, let's say to multiple insurance carriers for quotes, and it has dates of birth, not socials, but just dates of birth, is that considered? Okay.
No, that's not considered. It's generally, for enrollment purposes, you can do this, an exception for enrollment, where many employers get hooked up on this and where they get stung on this is many times they will review claims information, for example, with their broker or with their consultant. And that's where PHI really comes into play here. Or they have a wellness program and they look at the results of the wellness program. So this is where you have to be very careful. 9 times out of 10, when I go to employers and talk about this, the first reaction that many employers have is, well, I don't store or transmit PHI. 9 times out of 10, when I question them and I look at their procedures and I talk to the members of the HR department, 9 times out of 10 they do. So again, you have to be very careful. Look and see what you're doing and whether you do store or transmit PHI.
If an employee
relate to disability plans also?
No, it's just this, we're dealing with health plans, dental, vision, medical plans. That's what we're dealing with.
Okay, and what about when management wants to know information about somebody's health condition? You know, plans.
If it's summary information and the individual participants are not identified, there's no problem. So if you don't identify the individual, there's no problem. But if they review claims information, that's PHI, and includes the individual's name and if they're identified.
And what if there are employees sort of seated near the benefits department? They can overhear what's going on.
Could you repeat the question? I got interference for some reason.
But what if, like, there's another department near you that they can overhear your phone conversations about?
You got to be real careful. That's a violation.
I know. Okay. Thank you.
Basically, if you store or transmit PHI, again, the computers have to be secure. If you actually have it in paper, you have to be in a room that's locked, that has locked cabinets. And it goes to the point that if you have people coming in at night cleaning your offices, that information has to be put away. If you're working on a claim or you're assisting an employee on a claim and you leave it on your desk and you know there's people at night going around cleaning your office, technically that's a violation.
Thank you.
So please be very careful in this regard, okay? Any other comments?
If an employee sends an email to a broker asking for their help and sends them a copy of the EOB, is that proof enough that they've been given permission?
Yes, that's permission. But again, it all depends if it's just sent to the broker or not to you. It's a copy sent to you.
As a broker, yeah.
Yeah, then that's permission. I mean,
Okay.
if an employee sends that information to you, then they're giving permission. But again, if other family members want information about the claim, then you can't disclose it.
Okay, thank you.
Any other comments? Okay, let's continue.
Sure thing. Just give me a moment to mute.
Now, one piece of this is
The conference has been muted.
Over 10 years. It applies for electronic storage and transmission of PHI. And basically, there's certain requirements you have to demonstrate, and this is part of what they're looking at. Covered entities must implement appropriate administrative, technical, and physical safeguards for PHI. And basically, if you are sending claims information that contains PHI to the broker, to the insurance company, technically what HIPAA privacy requires is that email be encrypted. If information is stored on your computer, you have to take appropriate safeguards to protect PHI. Now, and these security guidelines only apply for electronic PHI. But again, oral and written on paper PHI is protected, but it's not subject to these rules. So any information transmitted by electronic means, maintained in electronic media, or maintained in any other form of medium is protected. And electronic media, what we're talking about here, is anything sent by email. So there are 4 security requirements. Again, if you get audited by the HHS, Department of Civil Rights, you have to demonstrate you ensure the confidentiality, integrity, and availability of all electronic PHI. You have to protect against any reasonably anticipated threats or hazards to the security and integrity of such information. Protect against any reasonable anticipated use or disclosure of such information that is not permitted and required, and then you have to ensure compliance with the workforce. Now, one of the requirements of HIPAA privacy is anyone who has access to PHI has to be trained in the requirements and the obligations of HIPAA privacy. So in this situation, what I would do, I would get your ID department or your computer technician to verify that the protections are in place under the HIPAA privacy rules. So what are the security requirements? There's administrative, physical, and technical safeguards. And your IT department can guarantee that those, and again, I have checklists that I can give you that outline exactly what those requirements are. But again, you have to demonstrate to HHS that those safeguards are in place. So if this only applies if you store or transmit PHI. So covered entities must use reasonable and appropriate measures to accomplish these requirements and engage in a risk analysis to determine how to comply. So you have to demonstrate to HHS that you've done this. So again, in electronic transmission requirements, all covered entities must standardize the format and content of all electronic information when engaging in covered transactions. This is called the EDI standards. And these are all the covered transactions. And basically what this is basically the administration of your plan. It includes health claims and equivalent and counter information, healthcare payment and remittance advice, coordination of benefits, health claim status, enrollment and disenrollment in a health plan, any eligibility for the health plan payments, referral certification and authorization, first report, injury, and health claim attachments all are covered under these electronic transmission requirements. And then, so what are these requirements? Under these EDI standards, covered entities in conducting a covered entity must use standardized formats and content as well as uniform codes in communicating with other entities. Only those entities that conduct standard transactions electronically or engage in these others are subject to the EDI standards. So this includes insurance companies, and TPAs that are doing this. And health plans are considered to be covered entities and must comply with EDI standards. So what are the transactions that are covered? Any covered entity or business associate, which means your broker, your TPA, if you're doing a covered transaction, has to comply with this. So covered entities must comply with EDI standards in certain transactions. So EDI applies to transactions transmitted using electronic media, does not apply to any transaction conducted in paper, doesn't apply to non-covered entities, and does not apply to group health plans under 50, and does not apply to health plan sponsors because they're not covered. So it applies to any transactions related to your health plan. So a group plan may not share PHI with its plan sponsor except for disclosure of de-identified information. You can share group health plan enrollment and disenrollment, limited summary information, PHI to a plan sponsor, personnel involved in the plan administration of the plan, and any time you when in doubt, pursuant to an authorization. Now, what this means, in layman's language, what this means, only those individuals with the employer working on the health plan can technically have access to PHI. So what we're talking about is that the HR director and his or her staff who work on the health plan have access to it in the administration plan if they adopt the HIPAA privacy rules. But if somebody that working for you that is the boss of an employee that has a claim and that person's out, you cannot share with them why they're out and why and what their claim is. So that's how limited this situation is. So again, health plans cannot provide access to PHI to plan sponsors without certain plan provisions and safeguards. Disclosure must be for administrative functions. And healthcare providers and health plans must use and disclose PHI with an individual authorization for any purpose. So again, when in doubt, in the use of PHI other than for the administration of the plan, what the law requires is the fact that you get an authorization from the individual participant. So certain health plan functions require an authorization. Plans may not condition treatment or payment on the receipt of an authorization. And in some situations, an employer may condition employment on receipt of an authorization. Authorizations may be required to obtain PHI for purposes of family and medical leave and ADA. So again, especially when you get the certification from the employer, you have additional questions from to that employee's doctor. You may need an authorization from there. An authorization may be required for an employer to assist employees with the claim, especially if you have not adopted all these rules. And an authorization may be required for an employer to receive reports from an EAP. Because in some situations, an EAP will include medical care. Now again, there's certain exceptions to these common employer practices. So certain common employer practices fall in these. You could have state and federal disclosure requirements And what we're looking at is the reporting requirements under ACA. Claims under workers' comp are not under this. What we're talking about here is claims under the health plan, not under workers' comp. And any health information that's contained in the employment record would not be covered, for example, if that person has a disability. So these are not covered under HIPAA privacy. We're talking about claims under a health plan. Now, because of HIPAA privacy, these are some of the special concerns that I have. And especially if you have protected health information on paper, please shred pertinent documents. Prohibit staff from accessing a participant's medical records to learn a neighbor's birthday or satisfy similar form of curiosity. And especially if you're assisting an employee or a dependent on a claim, do not leave messages about the participant's health on an answer machine or with someone other than the patient or doctor or whoever you're calling about. Avoid discussions about a participant's claim in elevators, cafeterias, or other public places. This doesn't apply. This more applies to doctors. This last one. Avoid paging a participant's using any information. Do not fax information without knowing that the person to whom the fax is addressed to is ready to receive it. And again, do not allow faxes to sit on an office machine. All right, Amanda, let's stop right here and see if we have any additional questions.
Absolutely, we have several in the question box right now. The first one, I'm the privacy officer for my employer's plan, a city government. Am I also responsible for privacy related to telecommunicators, paramedics, and police officers, as they may be exposed to PHI not related to the health plan?
Well, these require, there's various different privacy rules, and what we're just talking about here is information that's contained with the health plan. So there's other privacy rules that apply, but what we're talking about here is just HIPAA rules. That's all we're talking about. So what we're talking about is any claims or any information dealing with the health plan, that's what we're dealing with. Amanda, did you had several?
Yes, sorry, I was typing out the answers that everyone can see it if they go back through. For vendors working with small businesses on their benefit billing, which does have PHI, is the business agreement signed between the two parties sufficient?
Yes, but again, one of the things that's going to be contained in the business associate agreement, each party is agreeing under that business associate agreement that they're doing everything to comply with their privacy. You're swearing on that business associate agreement that yes, and both business associates and health plans have to adopt these rules and follow them in order to comply, because if you sign a business associate agreement that says you're complying with all aspects of HIPAA privacy and then don't adopt any of these rules or don't adopt a HIPAA policy, then technically you're in violation, and that's why HHS is going to be auditing business associates. So again, in 2010 there was a law called HITECH that changed these rules, and what HITECH did in 2010, they said business associates are subject to all the rules that covered entities are. So just because you're a broker or just because you're a TPA doesn't mean you have to comply with any of these rules. So you have to come up with a privacy policy, you have to train your people, you have to make sure you comply with these rules.
Does PHI used for the appeal panel review fall under the transmission, payment, and healthcare operation?
Yes.
Okay. As for the privacy officer, what level of the organization is this position?
Well, I think somebody with authority, someone who, if you see violations, can take some action. So it has to be someone I would think, that has authority if they see something going on to make changes.
Okay.
So I would think the head of HR would be a good person, or the assistant head of HR, somebody who has some clout in the organization.
Got it. Are there training or certificate programs available for privacy officers?
A number of organizations are, if you hate to say this because of the campaign, but I think there's a number of, I do it, other people do it, but there's a number of organizations that do HIPAA training. And I do it for my clients. I actually do it for benefitexpress. I do a HIPAA privacy every year for them.
Yep.
So I do it and other people do it. Yes, it's out there.
Could you, oh, that's for me. Does a HIPAA policy need to specify which individuals in an organization specifically have access to PHI?
Absolutely.
Okay. What is the schedule for sending out the privacy notice? Once per employee or annually?
Well, when they get hired in, you have to give them a privacy notice, and then every 3 years.
Okay, so upon hire and every 3 years. If you prepare 1095-C statements for clients, should you have a BA agreement?
Yes, because it contains PHI.
And must you have a BA with your email vendor and voicemail vendor?
If they have access to, I mean, if they have access to your, and they can review your emails, absolutely.
Okay. Pardon me. Is emailing about an employee's medical condition between HR manager and HR staff a violation?
It should be encrypted, because the problem is if you're sending an email and if it's not encrypted, it can be intercepted.
Mm-hmm.
So anytime an email contains PHI, even inside the organization,
Mm-hmm.
if it's not encrypted, it's not secure.
All right, and that's what I have for the question box. I will unmute so everyone can ask their questions now.
Does anybody have any other questions?
The conference has been unmuted.
Anybody have any other questions?
Is there a good source to get a format for a privacy notice?
I sell them. Other people sell them. If you send me an email, I'll show you what I have. But, I mean, if you, again, Google it, other people sell it. So there's a ton of organizations out there that sell. I mean, you don't have to correct it. You don't have to create it out of thin air. There are a number of people that sell it.
Thank you. I purchased a set, I think, from you a while ago, and there was one update about a year or two ago. But how do we keep finding out about other updates and
well, if there's any changes, I will let you know through my. Do you receive my email, my newsletter? Yeah. I will let you know.
And out of that set, because it was huge, which was fantastic, but out of that set, I was a little confused what went to the exactly had to go to the employees on the initially and what they needed every 3 years, because there were a lot of additional pages.
Practices, the notice of privacy practices.
Okay, thank you.
All the other forms are only upon request. That's the only one that's given out, but the others, if they request a change in their record or they want a restriction, that's when those forms are used.
Okay.
Now, see, what I've done in my package, which is important, is I have things that you can use that demonstrate you're in compliance with HIPAA privacy. I have timelines. I have security checklists. So if you get audited, you can show HHS what you've done. Any other questions? All right, well, why don't we continue?
All right, just give me a moment to mute.
This next section talks about
The conference has been muted.
HHS made some changes to them, and this section talks to this. Now, this is an extremely important section because no matter how hard we try, members of your staff will make mistakes. They will send a wrong email to the wrong employee or to the wrong provider, or somebody gets their car stolen that has a laptop in it, and that laptop contains all the claim information for your plan. Now, if there's a breach of security, there are certain requirements you have to do as an employer. What this section tells you is what a breach is, and then what do you have to do in order to comply with the rules under the final regulations. So the American Recovery and Reinvestment Act modified HIPAA. Security and privacy rules applied to, again, business associates, created a new notification rules for HIPAA privacy. There's a notice to affected individuals, notice to the media, and notice the Department of Health and Human Services. And the penalties for noncompliance were increased. So, again, most security rules apply to VA. Some security rules now apply to VA, generally effective in 2010. And the regs came out in 2013. So a breach is in a manner not otherwise permitted, which compromises the security and privacy of PHI. And again, so basically what we're talking about here is in a good situation, somebody at your place sent a fax to the wrong employer, or the wrong employee, or the wrong insurance company, whatever. That's what the most common situation. Somebody typed in the wrong email address. And instead of going to employee A, it went to employee B. Employee B received employees A claims information. So technically it's a breach. It compromises the security and privacy of PHI, sent to the wrong person. So the compromise is defined as a breach that poses a significant risk of financial and other harm. So VAs can make a judgment call about how significant the threat is. So what you have to do in this situation before you do anything is do a risk assessment, should be done and document and can be demonstrated. So if it's seen that there is a significant compromise, then you basically have to send out a notice. So during this evaluation, who permissibly used the PHI and to whom the information was disclosed, and the nature of PHI that was disclosed. For example, if the name of the individual, the plan participant is disclosed, that could be a privacy breach, but there's no harm. So it depends on the information in the email. If the types of treatment or other sensitive information, including social security number, account number, are revealed, there is a higher likelihood of harm. So again, many types of health details are sensitive because given the risk of employment discrimination. So effective for breaches occurring 30 days after the publication of, and this is 2010, these rules came into play. Now, there's a number of different exceptions here, and this means that if you fit one of these exceptions, you don't have to do anything. You don't have to notify anybody. So a secured PHI, unintentional acquisition or access or use by an individual acting in authority of a VA, inadvertent disclosure for one covered entity to another, or unauthorized disclosure where the unauthorized individual would not have reason of being able to retain the information. So a secured PHI means the fact you send a encrypted email to the wrong individual. Well, there's no harm because that individual couldn't open it. They didn't have the password. So, and because it's encrypted, that employee that received the wrong email, there's no breach, there's no compromise because he or she couldn't open it. Unsecured PHI that is not rendered usable, unreadable, or undecipherable. you send an email that's not encrypted to the wrong individual, bingo, there's an issue, there's a problem. So again, a secured PHI has to be encrypted. That's what this email, so again, for data in motion through the network, because if it's not encrypted, it can be intercepted before it gets to the place. Unintentional acquisition. Okay, unintentional acquisition or use of PHI workforce acting under the authority of the plan. So basically here, an employee who is responsible for billing receives an email that contains PHI about a plan participant from another employee. The email acts like consent. The billing employee opens the email, notices that she is not the intended recipient, alerts the employee who sent the email, and deletes it. There's no harm. There's no issue. It's inside the, or for example, you sent to the broker the wrong employee information. There's no harm. Yes, there's a breach, unintentional acquisition, but he or she deletes it. Inadvertent disclosure by a person who's authorized to access PHI at the plan, or at the plan or VA to another individual. A member of the appeals committee shares a PHI with the participant's PHI to another committee member. Member 1 thought the participant had appealed a claim, however, it was actually a different participant's appeal. Member 2 does not disclose or use the PHI, and therefore there's no issue and no problem. Or a disclosure PHI with a plan or VA in good faith belief an authorized person to whom the disclosure is made did not reasonably able to retain it. So a plan mails a number of EOBs to the wrong individual, and the EOBs are returned by the post office undeliverable. They were unopened, so there's no disclosure. Or, for example, you sent a wrong email to the wrong individual, you realize it immediately, call that individual up and said, you see that email I just sent you, delete it. Did you look at it? No. In that situation, that's an exception, there's no breach. So again, what you have to do, you have to determine whether there is impermissible use and disclosure PHI, whether impermissible use compromises the security and privacy of the PHI, and whether any of the exceptions apply. Now, basically what you do, if a breach is discovered, either through you or a VA, you should report the data to the plan within the time frame involved. And this is, the time frame would be stated in your VA agreement. Plan must notify each individual whose unsecured PHI has been or has been reasonably believed to have been accessed, acquired, or used. In some situations you have to notify the media. In other situations you have to notify HHS. So the discovery of breach, the first day in which the breach is known or should be have been known, that's when all the requirements come into play. So the plan and VA deemed to have knowledge of workforce members on any of the agents when they should have known in that situation. So if a breaching employee never tells anyone about the breach occurred but cannot be discovered, and therefore there's no reporting. And if it's a business associate, they must notify the plan after it discovers a breach. The VA must provide notice to the plan without reasonable delay, but in no event not later than 6 days after the breach is discovered. Now, in most of your VA agreements, that 6-day requirement is way reduced because that's the outside limit. And the VA must provide a list of each individual whose PHI was breached and other information. The plan must, again, notify each individual whose unsecured PHI has been used or is reasonably believed to have been used. Notification must be made without unreasonable delay, and again, you have 60 days from that breach was discovered to notify the individuals. Written notice should be sent by first-class mail. And if it's an urgent situation, then again, you have to be using by telephone or through email. When a direct notice is not possible due to the plan having insufficient information, you must, again, less than 10 individuals, a telephone notice or other means, and for more 10 individuals, there should be a posting on the website for 90 days. And this is the information that must be included in the notice. Plain language, brief description of what happened, type of unsecured PHI, steps an individual should take to protect him or herself, brief description of what is being done to remedy the situation, and contact procedures for individuals to ask questions. Now, you see stories in the paper about individuals who, again, an office has been broken into or a laptop was stolen from a car, and there's thousands of people, the records are on the laptop. So a notice must be provided to prominent media outlets in the state of jurisdiction if 500 or more residents of the state, their information has been accessed. So again, it has to be in the newspaper, and every once in a while you see that notice, but again, what we're dealing with is 500 individuals. That's when the media has to be notified. HHS. Notice must be provided to HHS if there is a breach of 500 or more individuals. Notice must be submitted within the same time frame for sending a notice to affected individuals. If there is an individual discovery of 400 individuals upon investigation, another 50 are discovered, you must notify HHS. So again, it's the total number. So again, it must be submitted within 60 days, as a login must be obtained and secure annually. For breaches of less than 500, you must submit it, again, 60 days after the end of the plan year. Okay, this is not important. I'm running out of time. Now, here are the penalties. Penalty amounts. Minimum $100 if you did not know the violation or were not unknown, with a maximum of $50,000 per violation of $1.5 million. Minimum of $1,000, maximum of $50,000 if there's a reasonable cause and not willful neglect. There's a $10,000 if there's willful neglect but not corrected, and the minimum of $50,000 if there's willful neglect not corrected, with a maximum of $1.5 million. Let's complete this and then we'll take questions at the end. As I indicated before, the Office of Civil Rights has announced Phase 2 as of March 2016. Here, what they're saying under these Phase 2 audits, a wide range of covered entities, business associates will be added to the list of audit targets. The Office of Civil Rights' goal is to have a broad sample of audited entities, covered entities, business associates that are going to audit. And these Phase 2 have 3 rounds. First of all, the first round is going to be remote disk audits of covered entities. Round 2 is remote desk audits of business associates. And round 3 is on-site audits. So the audit process will employ common audit procedures. What they're going to do is send you an email indicating that you're being audited. So if you get an email from the Office of Civil Rights, don't ignore it. And audited entities will submit documents online via a secure audit portal on the Office of Civil Rights website within 10 days of the receipt request. After reviewing the relevant documentation, auditors will share draft findings with the audited entity, and audited entities will have an opportunity to respond to any draft findings. The timeline for disk audits are quite compressed. Basically, when the email is sent, they want the information within 10 days. The auditor will complete the first report within 30 days, and then on-site audits will be conducted over a 3 to 5 day period. And as of desk audits, the audit entity will have just 10 days to review and submit any written comments. So again, everything acts relatively quickly. And then Office of Civil Rights has indicated that desk audits will be more limited than on-site audits here. And they've indicated what they're looking for, the protocol, which is what they're looking at. And here, what they're looking at is that It covers the notice of privacy practices, the right to request privacy protection under for PHI, access of individuals to PHI, administrative requirements such as training, policies and procedures and sanctions, uses and disclosure of PHI, and individuals' rights to request amendments. So these are things that they're looking at. So how should you prepare for an audit? Be alert. Look at emails from the Office of Civil Rights. Don't ignore them. They may send you more than one. Round up all the Office of Civil Rights inquiries. Have an audit response in place. Now conduct a pre-audit review. Remember, when you get one of these emails, time is of the essence. Know your business associates. Make sure they're all compliant because they could be audited too. And develop and update any compliance documents that really in this area. So please be very careful here. Amanda, are there any questions?
We don't have any in the question box right now, but I will unmute so everyone can ask theirs.
Does anybody have any follow-up questions?
The conference has been unmuted.
Are you going to send out slides?
Is any, yeah, we have slides.
We will send everybody a copy of the recording of the webinar and a link to download the slides after the webinar concludes.
Thank you.
So again, there's a lot of information. The reason I'm having this seminar because again, these second phase audits are coming. So this is this is the time to look at your procedures, look at your documents to make sure you comply with all these requirements. And this is a review of everything you need to do. If you have any questions or if you want to see the documentation of my package, let me know. My information is right here. I can help you with this. So again, let me know. That's my email address. Let me know how I can help you. Does anybody have any other questions?
I have a quick question.
Okay.
Laptop, it has PHI, but is encrypted to modern standards. Laptop is stolen. So you're in the position of having to disprove a negative in order to allege no harm. How do you do that?
Well, having your IT people certify the fact that whoever stole it can access the your emails. So a verification that the protections are in place. So in this situation, your IT department is your best buddy.
Okay. Thank you.
Any other questions? Well, again, thank you very much, and we'll see you on September 13th when we talk about Medicare and employers. Thank you very much, everybody.
Thank you all so much for joining us. We'll talk to you soon.